Welcome everybody to this event on responding to malicious cyber operations, state countermeasures. And welcome to those of you who are here in the room and also to those of you joining us online, including one of our speakers. I'm Harriet Moynihan. I'm an Associate Fellow in the International Law Programme here at Chatham House, and it's my very great pleasure to be chairing this event tonight. Responsible behaviour in cyberspace, in particular the role that international law plays in that, has long been a part of International Law Programme's work. And we're very pleased tonight not only to be hosting this event, but to be launching a paper on it, which I'll come on to in a minute. Before I do so, just a few housekeeping points. In the event of an emergency, please use the doors to your left or your right, but we're not expecting any emergencies. This event is on the record, so it's not being held under the Chatham House rule, and it's being recorded. If you'd like to comment on X by tweeting, then you can do so, for example, using the hashtags #CHEvents or hashtag Chatham House. The format for the event is that I'm going to be in discussion with our panel for about an hour. Then I'm going to open it up to you for questions, and hopefully you'll be able to throw out something interesting so that we can have an interactive discussion. If you're joining us online, then the good news is that you can already start sending in your questions, which I can pick up at any point by just going to the Q&A function in Zoom. If you're here in the audience, I'm afraid you'll have to wait to that point, but you can raise your hand and a roving microphone will come to you. We'll get on to the questions in a minute, but in the meantime, I'm going to have a discussion with our panel, and I'm delighted to introduce them to you. First of all, we have Shahzad Charania, MBE, who is Director of Legal Affairs at GCHQ. Shahzad, welcome back to Chatham House. I know that you do a lot of thinking in the government on these issues, so we're looking forward to hearing a government perspective. I'm also delighted to welcome from Vienna, live from Vienna, Nemanja Milicevic, who is Director of Digital Diplomacy at Microsoft. Again, very much a friend of the International Law Programme, has done a lot of thinking on these issues, and of course brings a very valuable private sector perspective. And finally, my colleague, Dr. Talita Diaz, who is Senior Research Fellow here in the International Law Programme, and very importantly for tonight, the author of a freshly published today International Law Programme paper on countermeasures in international law and their role in cyberspace. That paper is available on the Chatham House website. It's going to be, in due course, available in hard copy. But in the meantime, you will hopefully see flyers around with a QR code. If you'd like easy access to it, you simply scan the code and the paper will come up, and I heartily recommend it. It's very much part of a bigger initiative that the International Law Programme has been running for a couple of years now, called Cyberspace for All, which is really about encouraging diversity of thought around cyber issues and international law in particular, and that's with our colleagues, the International Security Programme. So congratulations to Talita on that paper. Before we start, I just wanted to perhaps frame the conversation with a bit of context. With malicious cyber operations on the rise, states are thinking about ways that they can effectively respond within the law. Often states will respond with unfriendly but lawful actions, which in international law is called retorsion, which might include, for example, the expulsion of diplomats, or perhaps trying to bring prosecutions, or even launching sanctions. But under international law, states can also take countermeasures in response to wrongful acts, both in cyberspace and beyond. And countermeasures are acts that would be unlawful, but they're actually justified when they're launched, in effectively, to try and stop or to try and repair a violation of international law that's taking place. Now, countermeasures, as we will hear, are subject to quite strict conditions, and the paper that I mentioned goes into some detail on those. So if you're interested, then do read that. We're not going to focus so much on conditions tonight. We're going to think rather practically about three particular scenarios. The first one is countermeasures by states that themselves are the victim of a cyber attack. The second scenario is when states that are not necessarily victims themselves, but may be indirectly affected, want to take countermeasures in a collective way, so that collective countermeasures, which is very much in the news at the moment. And finally, a situation where one state assists another state in taking countermeasures in response to a malicious cyber operation. My final point is that countermeasures are often not discussed explicitly by states. Often in the cyber context in particular, those actions might take place covertly, so we don't always hear about them. But we are hearing about them more and more at the moment, particularly in the Russia-Ukraine situation. They're actually very much in the news. So this event is very timely, and I'm sure we'll get into some of those important issues tonight. I'd now like to open up the discussion with the panel. And Nina, perhaps if I could start with you. Could you give us a sense of the threat environment that is currently taking place in the cyber context? And from your perspective at Microsoft, what kinds of malicious cyber operation are we seeing? Do you get the sense that they're getting worse? What is the sort of the threat environment right now? Over to you.
Awesome. Thank you, Harriet. I hope that you guys can hear me. It's a real pleasure to participate in this event today. My apologies that I could not make it over to London physically this time, not for lack of trying, trust me. So I hope you invite me again. I'll promise to be there in person if I can. So in terms of the threat landscape, I think it is fair to say that over the last several years, things have gotten worse. These are tricky times. Threats, frankly, to digital peace have reduced trust in technology, and they've also highlighted the urgent need, I think, for improved cyber defenses at all levels. What is encouraging is that we have seen both public and private sectors investing and collaborating to confront threats emanating from cyberspace, and I think discussions such as this one today are also really helpful. I do want to level set here before I continue about some of the other threats in the threat landscape, because I will speak a lot about nation state threats. Because in my role, when I speak about threats emanating from cyberspace, my primary concern really is usually with nation state threats. I don't want to trivialize any others, such as organized criminal groups, and I'll speak about those too. But I do want to call out nation state actors specifically because of the resources and the expertise that they can bring to bear. And let's take a quick step back here and acknowledge what this means. When we're talking about nation states threats, it means that you have people in the world that wake up in the morning, they take their kids to school and kindergarten, go to work, and all they do for the next 8, 10, 12 hours is think about how to attack you. When they're done for the day, they go home, pick up their kids, spend the evening, go to bed, and then they do the same thing again the next day and the day after, and so on and so forth. So this, meanwhile, you as a private sector entity, a think tank, as a government, you still have to do your day job, but now you have to do your day job while dealing with these types of attacks. So this is really a tricky position to be in, because in other words, when a country has decided that it is in its national and strategic interest to attack you, that really is a big deal, because there absolutely are countries that can pour near limitless resources into such an endeavor, which is something you have to take very seriously. And then on top of that, you have to deal with other threat actors such as organized criminal groups. And also, to be very clear, nation-state actors really were not alone in stepping up their abuse of cyberspace and the digital ecosystem. We've seen well-resourced cyber criminal groups also continue to grow and evolve using a cybercrime as a service ecosystem. We've seen ransomware as a service, phishing as a service. And again, so that all of this is not too abstract, we've seen case studies with the ransomware attack in Costa Rica by the Conti ransomware group in 2022, or more recently we've seen attributions, for example, by the US and others against the actor known as APT28, or also Fancy Bear or Strontium or Forest Blizzard against Germany, the Czech Republic, and a bunch of other countries. What else have we seen in terms of the threat landscape? Overall, the threat landscapes cyber attacks continue to increase in sophistication and frequency. And as the threat landscape evolves, we're seeing blurring of lines between cyber operations, between espionage, influence operations, and destructive attacks. So cyber operations have also become more public, often gaining more media attention with the ongoing use of influence narratives, trying to manipulate global and national opinion. We've seen a broader number of threat actors, both national and criminal, exploit newly released vulnerabilities more quickly, looking at destructive cyber operations. Even though the pace of, for example, Russian state-sponsored destructive attacks, I'll speak about those a bit later more, in the context of the Ukraine invasion, did decline. We've seen the variety of attacks increase based on looking at the big picture in terms of targeting what we've seen based on our observations. Critical infrastructure targeting remains very robust across the board, increasing again in the last year, with threat actors employing stealthier techniques to establish persistence. We've seen nation-state actors expanding their global target sets, meaning they're growing increasingly global in their approaches. In Europe, Ukraine remained the top European target per volume of observed activity driven by Russian actors. Israel remained by far the most targeted country in the Middle East and the North Africa region, as a result primarily of Iran's extensive focus there. In Asia Pacific, South Korea and Taiwan were the most targeted geographies, largely driven by North Korean and Chinese actors. And looking at the time, I feel I've admired the problem enough, and I can hear probably some of you think, hey, I hear you, Nina, what about some responses? So frankly, I'm also really curious to see where the conversation today will take us, but I think in terms of responses, they can focus on different approaches and take many different forms. Attribution and deterrence are some of them, for example. I have a lot of thoughts about that. Also, and I think I'll close with this for the time being, I think from an industry perspective, I think the focus really should always be on defense. This has also been our focus, for example, in Ukraine, and I'll speak about this a little bit more in a bit. But Harriet, mindful of time, let me pass this back to you. I can chime in on attribution and accountability after Shehzad and Talita again, not least because I'm also really curious to learn from both of them. So thanks for this, and back to you, Harriet.
Thanks, Nino. As I think very neat encapsulation of the threat landscape, if rather a sobering one. Sophisticated attacks getting more sophisticated, more frequent. The scale of them has grown. The seriousness of them has grown. And I guess we can make a link between the more serious attacks, and you mentioned attacks on critical infrastructure, and the likelihood that they may violate international law. I'm thinking about, for example, the prohibition on intervention in other states' affairs, as well as rules like sovereignty. And obviously, once you have a violation of international law, then that triggers a state's right to take countermeasures, obviously subject to the conditions that apply. So that may be why we're hearing more discussion around countermeasures and states thinking more about those, which I think is a good time to bring you into the conversation, Shehzad. It would just be useful to get a sense, I suppose, from a policy perspective, really, of what the relevance and significance of countermeasures might be in terms of the toolbox of options that a government has.
Yeah. So thank you very much for inviting me to speak on this panel. It's really good to meet you, Nino, and Talita, congratulations on the excellent paper. So I'll do some kind of level setting as well. And Harriet, you mentioned at the beginning that there are a range of responses in a state's toolbox, and you talked about the non-cyber responses that are there, from diplomatic responses to sanctions, to law enforcement, even to kinetic action if the relevant legal thresholds are met. So I think the first point to make is that we are talking about countermeasures generally, and that means that cyber is one option in the toolbox, but certainly not the only option. And I think in that sense, we have to differentiate between deterring cyber activity and using cyber to deter, right? Now, when we think about cyber as a response, I think I will start with the point that Nino was finishing on, which is the importance of cyber resilience and cyber security. And it's important for me to say that because the National Cybersecurity Centre is part of GCHQ. The legal team is one that I oversee in my role. And the work that we do in that cyber security, cyber resilience space is absolutely critical. It is the foundation of our national cyber strategy. So in the past, we've had, like most other states, cyber security strategies going back to 2009. We now have a national cyber strategy, a whole of cyber approach, which includes effects, but cybersecurity, cyber resilience continues to be at the absolute heart of that. So that's a really important point to make and to level set that, full stop. There are situations in which you need to reach in to your toolbox and deploy cyber effects. And there are particular situations where cyber effects are a good or even the only tool that you might be able to use. So, of course, cyber effects can reach your adversaries regardless of geography. You don't have to be physically present in a territory. it may be the only possible way or means in which to respond to a malicious cyber operation. A cyber operation can be precisely targeted in a way that a physical intervention might not be able to be. There may be a sense in which a cyber operation can constitute de-escalation in a way that other responses may not. And there's something in particular about a cyber response, as opposed to any other response, that can have a kind of cognitive effect, a kind of behavioral effect. So if we think about, pick your film, right? And you see the big red button that someone presses and the building comes down, or whatever other destruction you can think of. Now, in reality, that's not how cyber operations work, right? And it's important to get away from this notion of Hollywood culture about the effect of cyber operations and to think about it from a cognitive perspective. So, for example, you hypothetically could take down a website, say, of a terrorist actor, or take down a website that contains images of child sexual exploitation, right? You could have the tools to do that. And it may well be effective, but it may only be effective for, say, an hour or two until that site comes back up with added security such that you can't do it again. So one of the practices, one of the ideas that we've developed in 20 years of practice of cyber effects is this idea of a cognitive effect on your adversary. So what if you just jammed their website for an hour or two, or interfered with their communication so that they weren't able to send messages? The person on the other side is thinking, well, is this me just having a really bad IT day? Or can I really trust my systems? Can I trust my associate who's passed me some data? Is that person trustworthy? And that sows doubt into the mind of your adversary in a way that we, from our 20 years of practice, have found to be much more impactful and effective than simply taking down a website, which ultimately, in the medium to longer term, has very little effect. So I might just say one more thing, Harriet, which is having said what I've said, just to pick up on something you said in your very first sentence, Harriet, when you opened this session, which was about responsible cyber. And that is absolutely critical and is at the heart of our national cyber policy. And for us, responsible cyber has 4 components to it. So we say responsible cyber has to be transparent, inclusive, accountable, and what's the other one? I always forget it. Legitimate. There we go. And I won't go into the definition of all of those now, although happy to pick that up. But it ranges from everything to complying with domestic and international law, both absolutely critical, proper, independent, democratic oversight of your activities, and with Nino here, the importance in that inclusion space of private sector government collaboration. And we've seen that in Ukraine, the importance of that collaboration with Microsoft, but a whole load of other industry actors, which has been critical in Ukraine's resilience over the last, more than 2 years, well before that. I'll stop there.
Thanks, Shazad, and thank you very much for being kind of transparent about some of the responses in the toolbox of a government and the cyber effects you mentioned, while also taking place within a responsible framework. That is good to know, and I'm sure will be picked up on later. Talita, could I now delve deep into the legal framework, since you are very much kind of getting into that in your paper? Without getting too technical, it would be useful just at the outset to sort of understand whether countermeasures are permitted. If we take about the situation where you have a malicious cyber operation against a state, and that state is now an injured state, is that state permitted to respond with countermeasures, and in what circumstances?
Thank you, Harriet. Yes, of course. And it's a pleasure to be here today. Even though I've looked at this paper now probably 100 times, it's still a delight to be talking about this issue, a very important issue, as both Nino and Shahzad have highlighted. So the starting point in considering the international law around countermeasures is to note that in the past, there was some debate about whether or not countermeasures as a legal instrument were permitted under international law. So in particular, what we see, in the records of international law is that a lot of developing countries, or global majority countries, opposed countermeasures because they were considered to be archaic, or they were considered to favor more powerful states to the detriment of small and weak states that never had the capacity to or leverage to use those measures, right? And that's in cyberspace, but generally with economic measures, for example. But now it's quite uncontroversial that states that are injured, as you said, by a breach of international law, they have a right to take countermeasures to induce the state that has breached international law, what we call the responsible state, to comply with its obligations to either stop the breach of international law or repair that breach. And that right is recognized under customary international law. For those who are not familiar with the concept, customary international law are the unwritten rules of international law, which are formed by general or sufficiently widespread state practice accepted as law. And so the recognition of this right is the result of decades of very, very difficult discussions and negotiations on this topic at the International Law Commission, which is a UN body of legal experts. And the recognition of this right to take countermeasures also resulted in the adoption of the Articles on State Responsibility. So the Articles on State Responsibility recognize the right to take countermeasures under international law. And these Articles on State Responsibility, they have become the primary point of reference for the customary international law on countermeasures. And the articles, they not only recognize the right of the injured state to take countermeasures, but they also set a number of very specific procedural and substantive conditions for the taking of countermeasures in international law by injured states. So, for example, states must take countermeasures with the aim of inducing the responsible state to comply with international law. They can't be using countermeasures to punish the responsible state, for example. It can't be retaliation, tit for tat. The countermeasures must be targeted at the responsible state, not third states that have absolutely nothing to do with the breach of international law. Countermeasures must not involve the use of force. Countermeasures must not affect fundamental human rights. And, for example, they must also be preceded by a demand that the responsible state stop or repair the harm. And so these conditions, they resulted from very difficult negotiations between states having very different views on the topic. And so they reflect a very careful compromise between, on the one hand, the need to ensure that the conditions are sufficiently strict to prevent abuse and also to prevent escalation of disputes into armed conflict. But on the other hand, the right of the injured state to defend itself, to stop a violation of international law, to enforce international law, bearing in mind that the avenues for doing that are very limited because international law is decentralized. And so most of these conditions in the Articles on State Responsibility, they reflect customary international law. But there has been a lot of debate about the nitty-gritty, about how they are to be interpreted specifically in specific cases. And so these debates have now reemerged with great traction in the cyber context, because, of this need, this push to defend against malicious cyber operations, and because of certain prominent features of cyber operations that are unique to cyberspace and very different from traditional violations of international law. For example, cyber operations are very rapid. They're usually widespread and covered. And so there are a lot of political sensitivities around these operations. And so these operational concerns, they have prompted a lot of debates about the conditions for taking countermeasures. Even though, everyone agrees that countermeasures are allowed in cyberspace, so states can take cyber or non-cyber countermeasures in response to cyber or non-cyber violations of international law, there has been a push for these conditions to be interpreted a little bit more flexibly in cyberspace because of those concerns. And many states have come out with what we call national positions on international law in cyberspace, interpreting countermeasures in the cyber context. But what our research over the years at the International Law Program that culminated in this paper has concluded is that the conditions that we already have under customary international law for taking countermeasures, they continue to apply in cyberspace, and they are already flexible enough to address some of these operational concerns with having very rapid, very direct responses to malicious cyber operations.
Thanks, Talita. I think there's a lot there. I think you've really brought out the importance of countermeasures as an enforcement tool. I mean, let's face it, international law doesn't have that many enforcement tools, so this is very important. There are, of course, courts. I'm not saying there aren't accountability mechanisms, but this is a self-help measure that is about inducing compliance. So thanks for bringing out that. And also the fact, of course, that they shouldn't be abused, and that's where, of course, the conditions come in. It's not all plain sailing, as you said. It's a difficult compromise. And another issue that I think is sort of underlies all of this is that in order to use countermeasures, you have to establish that there has been a violation of international law in the first place, which gets you into the issue of trying to attribute a violation of international law to a state. And Nino, I wondered if I could bring you in here. I know the private sector is involved in sort of sometimes looking at issues around attribution, and I just wondered if you had anything to say on that or any of the other challenges that you see in this area.
Sure thing. So thanks, Harriet. I'm very happy to speak a bit more about attribution and the challenge of attribution and attributing things or malicious cyber operations to another state in particular. And I think, again, always to level set, as we all know in cyberspace, attribution involves 3 layers of analyses. There's a technical, a legal, and a political level. And countries really do need to consider all 3 before they make a public attribution. Now, obviously, states need to act fast, but I think it's generally also a good idea to cooperate with other stakeholders, if you can, with industry and civil society, especially as you are looking at the technical dimension of the attribution. But of course, whether a public attribution is made or not ultimately will always be a political decision and will likely always be a case-by-case decision taking into account a whole lot of geopolitical context. And I'm sure Shehzad has views on this. That said, I do believe that ultimately what we need is more robust and more consistent public attribution statements, not least because looking at the big picture, we actually need stronger accountability measures all up, accountability mechanisms all up. And I think cyber norms and other expectations, as we keep hearing, are regularly being violated with apparent impunity. And I think robust public attribution statements are a critical element. And we've been on the record, arguing for these. In our view, such statements are an essential first step in deterring malicious state behavior. Also, for example, last year's public attribution by the US of a cyber attack against Albanian critical infrastructure, to the best of my recollection, for the first time mentioned which international norms were violated in the attack, which I think always helps to underscore that such norm violations should not be tolerated. But again, I'm not naive. I understand that public attributions of cyber attacks are still a relatively new tool of statecraft with room to improve their impact via more comprehensive content and greater consistency. So I have a couple of things that I think that we think states should consider as they are putting these out is that there should be a uniform process, that content should be consistent. So there should be standards for in terms of making public attributions, and they should indicate as much as possible. And again, this is a case-by-case thing, but they should ideally state what happened, who was responsible, what was the impact, what information is the attribution based on, what, if any, international expectations were violated, might there be consequences, what happens next, and also what can mitigate similar attacks. Another thing to think about and that we support is this idea of cumulative attribution. So public attribution statements should make connections related to the broader malicious activity of whichever threat actor is responsible. So if a single incident is attributable to the threat actor, and if those folks have been responsible for other malicious activity online or offline, those statements should highlight the breadth of this actor's actions to promote comprehensive accountability, but also then to serve as a basis for appropriate consequences. And again, I do feel that as these attributions are being put together, they should leverage industry and civil society, where a lot of expertise lies in there. And I think in particular, one thing to think about could be for states to establish trusted points of contact within relevant companies to be informed in advance of a public attribution, which would then allow for those companies to determine on a voluntary basis if they have further insights to share, or attribution statements could leverage the work being done by credible academic and civil society groups, and in particular when it comes to their research on and explanations on associated harm and impact. Beyond attribution, and this was one of the findings of a workstream we did together with the government of Mexico and Temple University last year, and I think, Talita, you were also part of that, is that overall states should embrace data-driven approaches to enhance accountability, including greater monitoring and analyses of cyber incidents and the harms that they have caused. If I may, Harriet, I have also some views on Ukraine that I think might be relevant in this space. Do you want me to? Shall I do that now? Or shall I do that a little bit later?
Yeah, if you could do it now, Nino, it's obviously very, very topical and important.
So, I think what is helpful here to think about is in terms of Ukraine is this provides an interesting case study in terms of the role that private entities can have in helping governments respond to malicious cyber operations. And again, I think based on what we have seen, nation state and state affiliated threat actors have in the past year pivoted away from high volume destructive attacks in favor of more espionage focused campaigns. And while the impact of destructive attacks is usually felt more immediate, these types of persistent, stealthy espionage operations that we are seeing, they pose a long-term threat to the integrity of government, private industry, and critical sector networks. So that these are still really very big concerns and things to keep in mind. In particular, we've seen Russian and Iranian state-sponsored actors that traditionally have employed destructive attacks, most frequently changing the frequency of their destructive operations over the past year. At the same time, however, we've seen threat actors globally acted to increase their collective capacity against defense policy organizations, tech firms, critical infrastructure organization. I think we'll keep coming back to the critical infrastructure sector. I think that's just something that in this context is just super important. So to give you some numbers, in the high volume destruction attacks that dominated, I feel, the early stages of Russia's invasion of Ukraine tapered off, and nearly 50% of the destructive Russian attacks that we observed against Ukrainian networks occurred within the first 2 months of the war. Overall, we've also seen Russian state sponsors, threat actors use very diverse means, from phishing campaigns to exploitation of 0 days. And I think the other piece that's really important to keep in mind is, although most of the Russian state and state-affiliated intrusions since July 2022 were directed against Ukrainian organizations, more than a third were also directed against organizations in NATO member countries. And to close this out, I think what all this means, and again, I'd love to hear what Shehzad and Talita think about this, but I think what all of this means is that you have an extremely complex situation to navigate. And clearly, as is in the case of the Russian invasion of Ukraine, you have a situation where you had industry play a very active role in helping defend the country and all the consequences that entailed. So back to you, Harriet.
Thanks, Nino. And actually, you've already picked up on one of the questions. There's many questions coming in, which is great. One of them is about, how can we leverage better public-private partnerships? And thanks for that suggestion there, for example, of a government, a trusted point of contact within a company. This kind of stuff is very useful as well to understand better the threat environment with the Russia-Ukraine situation. So thank you. And Shehzad, I'll give you a chance to come back on some of that later on, if I may. But I'd like to now pivot towards a an even more contentious and contested issue, which is the collective countermeasures piece that I mentioned. This is a situation where there are two real scenarios we'd like to talk about here. One is what we call general interest countermeasures, which are measures taken to help the injured state against breaches of obligations that are owed to the community as a whole. So they're often known as collective countermeasures, sometimes as community countermeasures, or erga omnes obligations, and we always like to get some Latin in international law. So these states could be said themselves to be indirectly injured because the obligations are owed to the community as a whole. There's also another scenario that's coming up in discussions in the cyber context, which is countermeasures by states not bound by the obligation breached and thus not indirectly injured, but requested by another state that has been the victim of a cyber operation to take the countermeasure on its behalf, which is sometimes referred to as proxy countermeasures. So I think we need to plunge straight again into the law here, Talita, and just really if you could give us a sense of whether those are permitted under international law. I should add that the legality of collective countermeasures is being debated this very week, as you may know, by the G7 finance ministers, who are looking at the question about whether the billions of dollars of Russian assets, which have been frozen, should be used, sort of effectively confiscated and used as a loan to Ukraine. Which really is looking at a sort of a response to the Russian aggression for the full-scale invasion of Ukraine, whether or not that should entitle a sort of collective countermeasure of using this frozen asset. Some might say you don't need to frame it as a countermeasure and might be able to justify it under international law, but if not, then countermeasures could be a way forward. So that the legality of that's been discussed this week in Italy. So this is very topical stuff. So Talita, with that, over to you. And if you're able to touch on Russia-Ukraine, that would be interesting.
Yeah, so if I may, before I go into the nitty-gritty of the law, it is also important to bear in mind some policy considerations that weigh in favor or against these various types of collective countermeasures. And, you know, there are several arguments in favor or against both types, but, you know, some arguments that, you know, certain scholars and states have, you know, pointed to, like, against that way against having these measures are the destabilizing effect that they might have on treaty relations. Also, the fact that these kinds of collective countermeasures might undermine the role of the Security Council, which has a mandate to, you know, maintain international peace and security in a collective way already. You know, there's also a point that has been raised time and again that collective countermeasures might increase the risk of escalation, you know, because you've got a number of states taking measures that in principle breach international law, very serious measures. So these are some of the considerations, the policy arguments against, but I'm sure Nina will come back on the policy arguments in favor. Of course, the defensive argument is very important, and if you have states that have very different cyber capabilities, especially developing countries or small states that don't have cyber capabilities, it is important that they have some sort of assistance when defending against malicious cyber operations. And in the case of general interest countermeasures, you know, you can have a situation of a state that is committing violations against, you know, its citizens or against private entities in its territory. For example, human rights violations, humanitarian law violations. And in that case, general interest countermeasures might be one of the few ways in which, you know, states can address the situation and safeguard the rights at stake, because there's no state that is individually or specifically affected by that situation. It's individuals that are suffering. And so in that case, general interest countermeasures might be important. But as far as the law is concerned, I think there are two preliminary points that we need to consider or bear in mind when considering the legality of both types of collective countermeasures. And the first one is that, as Harriet said, the concept of an injured state in the Articles on State Responsibility is very narrow. In very simple terms, it basically includes the state that is individually injured by a breach, or the state that is specifically affected by it or necessarily affected. There are lots of, you know, complicated, complex questions, but basically that's in essence what it is. And so that's a very narrow group, a very small group of states. So that's why we have been hearing calls for collective countermeasures. The second important point that we need to consider there is that in the case of general interest countermeasures or collective or community obligations, erga omnes, as Harriet said, the fact that a state has, or all states have, a legal interest in protecting these obligations doesn't automatically entitle them to take countermeasures, right? So a legal interest in protection is different from a legal right to take countermeasures, which are measures that are very serious. They, in principle, breach international law. So if that exists, if the right to take those countermeasures exists in customary international law, it must come from sufficient state practice and opinion juris. So views are very divided on this. There's a lot of debate. States and scholars are, divided. We've had a number of roundtables on this, and, people couldn't agree on the topic. And the International Law Commission, when it discussed the topic back in 2001 and before, it was also very divided. States there were very divided. Developing and developing countries disagreed that these measures were grounded in customary international law, despite several voices in support of general interest countermeasures. So in 2001, when the articles were adopted, it's difficult to say that they were part of customary international law. But it's also fair to say that that practice that we have on general interest countermeasures has evolved significantly over the years, and that practice has been spearheaded mostly by the EU and Western states, and also prompted by Russia's invasion, full-scale invasion of Ukraine. As we know, many Western countries, as Harriet said, have adopted measures that might look like countermeasures in response to the invasion against both Russia and Belarus. So, for example, asset freezes, now confiscation, aviation bans, trade restrictions, and so on and so forth. And these might look like countermeasures, right? And many states have come out with a public position in their national positions on international and cyberspace supporting these kinds of general interest countermeasures. But there are so many challenges in assessing the practice that we have, challenges that I face in writing that paper. And some of them include the fact that states, like Harriet said, they don't label the measures that they're adopting as countermeasures, so we don't know what they are. Many don't consider to be taking countermeasures. So, for example, on asset freezes, many states don't think that asset freezes are unlawful under international law, and so they don't need to be justified as a countermeasure. So it's very difficult, and most importantly, there are many objections from both developing and developed countries like France, Canada, Brazil, China, against this concept of general interest countermeasures. So the evidence that we assessed is at best ambivalent on this, and it seems insufficient at this point. And because we need, as I said, sufficiently general practice that is accepted as law for a new rule of customary international law to emerge, we can't really say that at this point these measures are permitted. But the law is very much in flux, and states should be speaking out, either in favor or against, whether they accept that. But, to Harriet's final point about proxy countermeasures, very, very briefly, even though the views on general interest countermeasures are very divided, it's quite uncontroversial, except for 2 states and maybe a few scholars, it's quite uncontroversial that proxy countermeasures, so these are countermeasures that are taken by states that are in no way interested in the violation of international law. So these kinds of countermeasures are not permitted under international law. There's no support, there's no legal basis in international law for that. And that applies both online and offline.
Thanks, Talita. And I think your paper does a very good job of, as you say, taking what's quite difficult methodologically to work out whether states are actually meaning their actions to be countermeasures or not, and to go through the evidence and form a balanced view. Scholars do have different views on this, differing views, and so do states. If you want more detail, it's very much set out very clearly, I think, there in the paper. So thank you for that. Shazad, if I could turn to you. I don't know how much you feel you're able to say, but it'd be very interesting to hear any thoughts on the UK's position on collective countermeasures, and I guess the kind of considerations that you take into account when thinking about them.
Yeah. Gosh, there's so much to respond to that's been talked about in the last 15, 20 minutes or so. So maybe I can pick up just one thing, and then we can deal with the rest maybe in the Q&A. And it's just on the point that Talita raised when talking about the conditions around countermeasures, and in particular this question around prior demand. Do you have to require do you have to make a prior demand of the state, of the aggressor state, or whatever you want to refer to it, to stop their malicious action before you respond. And the UK's position, actually, which was set out, I think, in this very room in 2018 and then again in 2022 by successive attorneys general, was that, and is that, it is not necessary to request prior notice. And that's for a number of reasons, but mainly because the UK's position, like that of many states that Talita refers to in her paper, is that a state is not required to compromise the kinds of covert capabilities that it has, which may have led to it realizing that there was a malicious cyber action being taken against it, to which a countermeasure would be appropriate. And of course, the ILC articles themselves talk about scenarios in which you don't have to make a prior demand, and it refers to urgency as a reason, as a scenario in which a prior demand is not required, but we say that it should go a bit further than that. So on the question of collective countermeasures, could go back to 2000, and when the UK set out its position in response to the ILC's articles. And at that point, we expressed the kind of caution for we expressed caution for the kinds of reasons that Talita has set out, that mainly really the destabilizing impact of states being able to get together and respond on behalf of an injured state. The Attorney General in 2022, in making her speech here, said essentially, I think, has noted that the position of the UK hasn't changed effectively, and kind of offered a question as to how the international law framework might adapt to a situation where a state is affected by a malicious cyber operation, say, and where it itself doesn't have the capability to respond, and how states might think about reacting or responding collectively. Now, I think the key point is that all the caution that you've talked about, Talita, is still very much at the forefront of the UK's mind, which is why its position hasn't changed on this point. There's perhaps one other thing to mention just on countermeasures more generally, and I'd be interested in Nino's view on this, which is what we mean by that term in and of itself. And certainly in the cybersecurity world, where I also work, it means something very different to the international law world where I work. So in cybersecurity, countermeasures are about cyber responses to malicious cyber operations. We talk sometimes about electronic jamming, in other words, jamming signals so that malicious cyber operations are unable to have the intended effect. But of course, in that sense, countermeasures are not necessarily responding to a prior act that was contrary to international law. It's just a term that's used when responding to some sort of malicious operation against you. The other note of caution, as well as the terminology, is that and this is very well laid out in your paper, Talita, is that many of the states, I think, that have talked about collective countermeasures haven't themselves necessarily differentiated between general interest countermeasures and proxy countermeasures. So it's quite difficult, I think, to talk about what states mean when they say they're in favor of countermeasures. I think Estonia has talked probably the most, or is the most forward-leaning in terms of the countermeasures regime. But it's not clear when you take together all the statements that have been made what kinds of collective countermeasures they're referring to. So while states are talking about this in a cyber context, it's important to remember that because states take the view that international law applies to cyber as it applies to any other domain, and therefore that what you say in the cyber context about collective countermeasures therefore also applies in the non-cyber context, we should be very cautious about what states are actually saying on this question of collective countermeasures.
Thanks, Shazad. And I'd really like to pick up on that point just now on terminology. Quite often in the press you see rhetoric around countermeasures, and it's very important to look at the context of that, because countermeasures, as we know, is a term of art in international law, and it's often used under, well, it's very specific circumstances. So there's that, and then as you highlight, Shazad, there's the fact that some of the national position statements aren't always that granular or precise, so it's not always entirely clear what type of countermeasures they're talking about. Nino, and I must apologise for peering into this screen here, but there's a lot of questions coming through on Zoom. Thank you very much for all those who've submitted questions so far, and we will get to them. But I'm trying to sort of marshal them at the same time. Before we get to questions, I'd like to give everybody a chance to have a final round, including on the issue of assistance to another state. But Nino, perhaps I could come back to you. I don't know if you have any comments on what you've heard so far, in particular Shazad's point about the use of countermeasures in different contexts, but also this general trend for states to want to collaborate together in responding to cyber operations, which kind of makes sense given the increasing threats that we're seeing. But what do you see as sort of the policy imperatives behind that? Are you seeing that yourself? Can you see any risks around that collective action?
Thank you, Harriet, and that also. So a whole bunch of I had to chuckle, and I took note when Shazad said that, you know, what does it actually mean when states that say that they are in favor or not in favor of collective countermeasures? Because again, I think the devil oftentimes is in the detail, and I think that is a very interesting conversation to have. I think the other piece to bring in as we are contemplating all these is to also think about what are we actually trying to achieve here, and much of this still is focused on achieving, you know, a deterrent effect of future attacks. And again, I realize deterrence in cyberspace is traditionally been a really tricky issue, but I feel that's kind of the context within which I've been also thinking about this, because the reality is that conflict in cyberspace really continues to escalate despite diplomatic efforts to establish limits to particularly state behavior online. And I do think that when it comes to the cyber domain, as with any other domain of conflict, we do need a meaningful deterrence framework to prevent, you know, dangerous and escalatory activity in cyberspace. And what we have been seeing is persistent nation-state cyber attacks on critical infrastructure, including cloud services, putting civilians at risk, which again reflects the need for a more robust framework here. Now, I acknowledge, and you've touched on this, Harriet, that there are asymmetries in the cyber capabilities among states, and I always acknowledge that you will need to strike a balance between the deterrent effect that you're trying to achieve or that you can reasonably expect to achieve and the likely or potential risk of escalation, and I think Talita touched on this as well. So realistically, I think what all this means is that there won't be a one-size-fits-all solution. I think, at least for the time being, governments working together and working with other stakeholders will likely have to look at these situations and evaluate them each on their own merit on a case-by-case basis. And again, I think from an industry perspective, I do want to stress again that I believe that our involvement should be defense-focused rather than focused on offensive cyber capabilities. Ukraine, again, I think is a good example where you had Microsoft and other tech companies as well provide pretty unprecedented tech support and assistance, whether it was by dispersing digital infrastructure into the cloud and across data centers across Europe, so as to protect them from Russian missiles, or a whole host of other things. And again, I think these are all worthwhile things to do. And I think as we're thinking about this, and I look forward to hopefully in the Q&A go into more of the potential public-private partnership or multi-stakeholder diplomacy angles off the topic, because I feel that focus then also helps reduce the risk of escalation, and or as states sometimes like to characterize it, to help prevent the loss of escalation control. I always love that term. So back to you, Harriet.
Yes, well, we love to champion multi-stakeholderism here at Chatham House, Nino, so thanks for raising that. And as you say, it's come up in the questions, so we'll get into that in a minute. Before we do that, and before we get to the questions, because I'm sure that you all have many thoughts, I'd just like to quickly talk about the final scenario I mentioned, which is this situation where one state assists another state in countermeasures. So we might imagine, for example, in the cyber context, that we have a small state that's the victim of a malicious cyber operation, and that state doesn't have the capacity to know where the cyber operation is coming from. It asks for help from a perhaps more cyber active, bigger state who provides intelligence on where the cyber operation is being launched from and the infrastructure it's coming from, which then helps that victim state to launch its countermeasure. Now, there are a number of rules that will be relevant when the assisting state is thinking about providing that assistance, and those go beyond the countermeasures rules. And we partly wanted to flag these up just because it shows, I think, perhaps the sort of complexity that government legal advisors have before them when they're thinking about these issues. But just to touch upon it briefly, Talisha, I don't know if you could very briefly, given the time, outline the regime on assisting and the kind of things governments need to think about.
Sure. If I may start with the conclusion that we reached. So in that paper, we conclude that irrespective of all of these difficult debates about collective countermeasures, the most would agree that third states, states that have nothing to do with the breach of international law, indirectly, directly injured, non-directly injured, they may still aid or assist the injured state in taking its own countermeasures, right? It's not taking countermeasures on behalf of the injured state, but it's helping that state take its own countermeasures, provided that that assistance complies with international law. And the basis of this conclusion is that, you can, even though a state cannot assist another state in committing an internationally wrongful act, it's like complicity in criminal law, right? You cannot assist someone to commit a crime, even though your assistance is perfectly lawful, like providing funds or training or whatever. You can do so by, you can assist a state in doing something lawful, and countermeasures are lawful. So that's the reasoning behind. And so basically that alleviates some of the concerns that we have with asymmetries in capacity, cyber capabilities, but also without having to go as far as allowing third states or indirectly injured states to take countermeasures. So in very brief terms, that's what assistance is about, the legal framework.
Perfectly succinct. Thank you, Talita. Shahzad, I don't know if you'd like to add anything to that, or indeed comment on anything you've heard so far before we open up.
Yeah, so certainly on public-private partnership, maybe I'll pick that up in the Q&A if you say there's lots of questions on it. Just on this point about aiding and assisting, the UK, I don't think the UK has ever set out an explicit position on this point, but of course we would agree with the conclusion that you've come to, Talita, in your paper, which sets out the arguments very well. And just because I see her in the audience, Federica Padu has done a brilliant paper on this too, with Miles Jackson, which really lays bare some of the additional complexities around what seemingly might be quite a simple idea when you just state the conclusion as succinctly as you did, but actually there is some interesting complexity behind it too. Absolutely,
yes. I should give a shout out to that paper too. Maybe we can, put a link in the chat for those of you that are online. But it's just come out and it provides great insights. I think I'd just like to turn, Nino, to you for any final thoughts before we open up. I mean, particularly on the issue of accountability. We talked about the countermeasures as a kind of tool of enforcement. And do you think there's a value in this as a form of accountability? Can you think of any other forms of accountability? And is there anything that you want to talk about yourself in terms of the public-private partnership issue while you're on? And then we'll bring in some more questions.
Thanks, Ariel. I'll be super brief. And again, like Shahzad, I'll happily pick up on any PPP or multi-stakeholder angle as questions come up. But in my mind, I think the biggest benefit really of countermeasures and thinking about them and talking about them and also implementing them is as a form for pushing for more accountability. The idea being for all of us that you want to counter and prevent a reality where malicious actors believe that they can carry out their attacks with impunity, because that obviously only benefits the bad guys. I'll say it again, the reality is that conflicts in cyberspace continues to escalate despite our best efforts to establish, or diplomatic efforts to establish limits on state behavior online. And this means that, as within any other domain of conflict, a meaningful deterrence framework is necessary, I think, to prevent dangerous escalatory activity in cyberspace. We've seen persistent nation-state cyber attacks on critical infrastructure, putting civilians at risk, and there's a clear need for a more robust framework to counter this. So I think there should be a countervailing pressure from the international community. And of course, as Talita keeps also saying, ultimately all this needs to be backed by international law and by common understanding thereof applicable to this context. I'm not sure that the international community is quite there yet, but it remains a much needed and very worthwhile ambition. And of course, papers like this are driving the conversation in exactly the direction they need to go. And ultimately, I think collectively, government, industry, and civil society, we need to figure out ways to increase and improve accountability. I'm looking at the time. I'll stop here so that we have about half an hour for questions. This was really fascinating so far. Thank you. Back to you, Harriet.
Thanks, Nino. That is indeed perfect timing. I'm going to open it up to both the room and to those of you on Zoom who I can see have been already very active. Just a quick reminder, if you'd like to raise a question or a comment, then if you're online, you simply, I can see you're already doing it, but you type in the Q&A function on Zoom. If you're here in the room, you simply need to raise your hand. Please stay seated. And if you could say your name and affiliation before you raise your question, that would be great. We'll have microphones coming to you. If we may start with the lady at the back, I believe, Emily.
Thank you very much. Emily Taylor. I'm an Associate Fellow of the International Security Programme here at Chatham House. Great discussion. Thank you very much, all of you. And just reflecting on Nino's closing remarks, I mean, in a way, those could have been said at any panel over the last 10 years. And my question to you all is, what signs of hope do you see, or what will it actually take to shift the balance back, away from this culture of impunity? And can you give us any examples, concrete examples of progress that give you hope?
Thank you, Emily. Very poignant comment. And I'd just like to take one more in the room, and I'm going to take a couple online. We have so many coming in online, I'm going to be grouping the questions. But is there anyone else here in the room that would like to make a comment? Please.
Pete Apps. I do various things, but I'm a columnist for Reuters. We've been talking a bit about as if cyberspace sort of occurred in a vacuum, but actually these sort of unorthodox acts are intensifying, if anything, by the week at the moment, moving buoys around, cutting through fibre optic cables. To what extent is cyber an appropriate or a valuable way in responding to something that takes place outside the cyber domain, but often sort of outside the sort of kinetic warfare kind of world? And the second sort of rising point to that is, we're all talking also as if international law is a thing. And I don't necessarily know that feels like that is internationally accepted at the moment. And so I'd be quite keen on the panel's thoughts as to where international law is going, and whether it's becoming something that just some countries believe in, and to what extent it can be re-established as an actual norm.
Ooh, a sucker punch. Thank you for that one. Yes, well, I'm sure the International Law Programme has some good responses on that, but thank you. That's very, again, as you say, topical. These arguments come up. I'm just going to throw out a couple of questions that we have online as well, and then we'll go to the panel. We had a really interesting one here from Axel Charles about artificial intelligence. There are a lot of protections regarding the trajectory of AI. Most of them promise an increased level of autonomy in various domains, including cybersecurity. What are the main risks and challenges that AI-enabled cyber operations pose in terms of impact? And are countermeasures enough to tackle these risks? And I think the question that's really interesting here is, can autonomous cyber operations be considered viable and legal countermeasures under international law if their autonomy carries an increased risk of unpredictability? So thinking about countermeasures that might involve AI. We've already talked about some of the difficulty around the conditions and the importance of those protecting from abuse. So that's something that I think is quite topical. I think, if I may, I'm going to go to you first, Talita. I'm quite energized by the question on international law to start with. But we've had a few questions there. Obviously, we've had the question of hope that Emily raised. We've had the question about whether cyber is appropriate to respond outside cyber domain, and then we have the AI question. Any thoughts on any of those?
Sure. So I'm very hopeful personally about these developments, and the reason for hope is every time I have the opportunity to go to New York to the open-ended working group on cybersecurity, and even though there are divisions, debates, at the end, states always agree on something, right? That's the starting point, and states have over the course of the last decade, they have come together to agree on at least the bare minimum, right? And so these bare minimum principles of, for example, international humanitarian law, human rights law, that the UN Charter applies in cyberspace. So that gives me hope that, states that are so different, like Russia, China, the UK, the US, they have come together and agreed on these foundational rules. To me, that gives hope. And right now at the OEWG, the UN Open-Ended Working Group, we're talking about moving away from discussions about the law and theory to practical case studies. And it's far easier to agree on, what is prohibited and permitted if you look at, the realities of cyberspace. So I think that's a good approach. And that gives me hope, and I think that's the way forward. On international law, if it's a thing, of course it's a thing. Our international community is founded upon it, and it's no wonder why states are being very cautious about, for example, confiscation in the case of Russia, Ukraine. No wonder we've seen the announcement by the Office of the Prosecutor this week with the application for the arrest warrant. So that's the international community raising international law and battling for its continued relevance. And I think that's also present in cyberspace. As I said, many states have issued these national positions, and that's a symbol that they still believe that even in cyberspace we have rules, that apply.
Yeah, thanks, Talita. And I suppose that we've talked about countermeasures as a kind of instrument that is a means of enforcement. So hopefully international law is being actually useful, is actually a tool, as well as something that is the foundation of everything. Nino, could I turn to you? I don't know, be interested in any thoughts on the AI point, given that that's the direction of cyber, in both cyber defense and cyber offense, and also any points that you might have on we've picked up on this before, but on partnerships and multi-stakeholderism. If you have any thoughts on the value of international law, we'd be interested in that as well.
So I'll leave the evaluation of international law to Talita, and I leave also the evaluation, as I think Shahzad has already done that previously, the evaluation of whether cyber is an appropriate response to kinetic attacks. To him, I think he tackled that previously, and I thought that was actually very interesting. I did want to comment on the hope thing as well, but let me touch also on the multi-stakeholder PPP piece, because that's linked to the hope piece as well as on the artificial intelligence piece. I think AI will, of course, be a critical part of cybersecurity going forward. I think the position that we are having is that for the first time, we are in a situation where we believe that you have a technology that will actually benefit the defender more than the attacker. I think that is kind of where we are putting a lot of our efforts and resources to ensuring that is a development that we're seeing. I think that will be one of the critical pieces to focus on going forward. And hopefully this is going to be something that will help us counter that trajectory that I think all of us, as I think the lady that asked the first question correctly said, that I think for the past 10 years, we kept saying the same thing, that the trajectory is actually not that threats have increasing and that the trajectory hasn't been very good. So I think that will be a very interesting, those will be interesting developments to monitor. On what gives me hope. Now, when I look at these things, I always try and look, I'm a big proponent of hope is not a strategy. So I try to look at things, what is it that I can actually, or that we can actually do about things. The reality is that you have situations at the UN where, in particular, where a lot of very important cybersecurity discussions are currently taking place. Talita mentioned the open-ended working group. The one hope that I'm seeing, or the positive developments that I am seeing, is that you have a large group of countries, UK being one of them, that have understood the importance of tackling threats emanating from cyberspace is too big just for governments, just for industry, just for civil society. You need to find ways to do it together, and they've been vocal at engagement at mechanisms like the UN to allow stakeholders in the room. The positive example has actually not been the open-ended working group. It's been currently the negotiation on a UN convention on cybercrime, which in itself is a problematic convention, but be that as it may, the multi-stakeholder modalities are the most favorable of any UN process so far, where you've actually had meaningful multi-stakeholder participation. In the open-ended working group, it's actually not all that open, because countries like Russia and China can still individually veto the participation of individual actors. Microsoft has, for example, traditionally gets vetoed by Russia. Most recently, we got double vetoed by Russia and China, which was, I take it as a badge of honor. They really didn't want us in the room. I feel there's a lot of negotiators after that didn't want to see my bald head in an additional negotiation. But be that as it may, ultimately, I think what we need to really think about in this space is create environments where you can have countries, liberal democratic countries, government, industry, and civil society fight the good fight together, because ultimately I think we want the same thing here.
Thanks, Nino.
Which is a free and sustainable internet.
Some shards of hope there. Thank you. And Shazad, do you want to pick up on any of those questions?
From one bald head to another, yes. Let me pick up on the hope question and link it to the accountability point that we were also talking about. And this is probably a bit of a parochial thought, but one of the key issues for us that we've been looking to promote is transparency. And I mentioned that this was one of the 4 principles for us in responsible cyber power. And we've done that in the context of cyber effects, or offensive cyber, and through a particular publication that's online called Responsible Cyber Power in Practice. And it's, as far as I know, the most extensive kind of publication that sets out offensive cyber doctrine that's out there. And that's really important for us. For reasons of transparency, but also for reasons of accountability, so that we can set out the standards to which we hold ourselves. So in that, we also talk about our operating principles, and one of those is accountability, that everything we do is lawful and ethical. So I think from that foundation, I hope that there's hope, in the sense that we want to start a movement that enables and creates an environment where other states are also going to talk about how they operate in this space. We've seen the advent of that from years back in terms of states setting out their interpretation of international law in cyberspace. So we see this as the next kind of iteration of that. How do you actually operate in cyberspace? What are the doctrines? What are the practices and processes that you deploy? And so when I mention that within the context of accountability, it's about, for us, being lawful and ethical, that perhaps then segues nicely into this question of, is international law a thing? And I can be very specific in saying that we would not proceed with an operation in the effects/offensive cyberspace if we considered it violated international law. That would be a red line. So I hope that demonstrates that for us, for the UK, it's a thing.
But over our adversaries, that appears not to be the case.
Yes.
It's all the more important that we seek to uphold it, I suppose. Now, I'm conscious of time, that we have so many questions online, so I'm going to go to some of those and pick up a couple in the room as well, and we'll try and keep our answers brief so we can get through as many as we can. There is a question from Kubo Masak, which is for Talita, which congratulates you on the new report. And one of the recommendations in your report, Talita, is that states should be clearer and more transparent about their views on cyber countermeasures. How could the legal and technical capacity of states be strengthened so that they can confidently and develop and share their views? So capacity building, that's important. We have quite an interesting comment from Mary. Just trying to pull it up. Sorry, bear with me. Which is about, it's sort of about the public-private partnerships. And Nina, I was thinking of you on this. Is it a problem that, as we saw with Elon Musk's provision of Starlink, he who gives can also take away? So I suppose thinking about sort of the regulation of the private sector somewhat, as well as the sort of active participation of it. And then Shazad, I think we have a question for you, which is around your use of cyber effects and whether you meant offensive cyber, and if you were squeamish about that word. It'd be interesting to hear if you've got any comments on, because different states use different words for those things, don't they? Okay, over to you in the room. Is there any questions we'd like to add on here, or any comments? Do raise your hands if you have any. Yes, we have one in the centre there. Thank you.
Hi, I'm an Arabic student at SOAS. We've heard about countermeasures to our official enemies. What about countermeasures towards our allies who may, hack our industries for competitive advantage or state secrets? So how do we respond to them? Do we respond to them in the same way? Thank you.
Thank you. And I suppose a couple of comments that we've had, they're kind of questions, they're kind of comments, which is around, how do we use countermeasures against state-sponsored cybercrime? So we've talked a lot about sort of particular cyber operations, for example, attacks on critical infrastructure, but where the malicious cyber attacks are state-sponsored, they could take other forms, ransomware, cybercrime. We've also had a question from Andrew about potential cyber attacks on UK elections, given the election's just been announced, and whether countermeasures could be relevant to that. I guess these are all quite fact-specific scenarios, but just to throw them in there. So quite a lot there, I think. Nino, I don't know if you had any comments on the Elon Musk Starlink point, or indeed on any of the other things that you've heard, just briefly, because we would like to get through some more if we can.
Sure. I think what I would say to this, though, and I think the question was along the lines of "He who giveth can also taketh away." I thought this was interesting to see that framed as a directed at the private sector, because that frankly applies to everybody who giveth. States have been known to give and then taketh away again if it suited their interests. So I feel that framing is worth thinking about in broader terms. I don't necessarily see it as something that is specific to the private sector. I do understand that that the example given with Elon Musk and Starlink is something that that was heavily reflected in the media, which is why it's top of people's minds. But it's something that, conceptually, I think it goes much broader, and I think takes away from the bigger issue in question, which is how can we get governments, industry, and civil society to better work together and basically give in all of these situations to help countries that are in dire situations better defend themselves against the types of cyber or other attacks that they're facing. And I feel, again, from an example perspective, Ukraine remains the most top of mind example of, I think, positively what we have collectively seen.
Thanks, Nino. Talita, if I may come to you. Obviously, we've got the question from Kubo on capacity building. There is actually another one here for you as well, which is about the legitimacy of countermeasures in the general interest, given that most non-Western states are against it. I thought it would be interesting to pick up on your point about non-Western states and the fact, I think you mentioned that only actually in the cyber context, relatively few states have come out with their position so far, and those are mainly Western. So any thoughts on the non-Western or global majority point?
Sure. I mean, some global majority states have been issuing their positions, developing those positions. One example is Costa Rica. Recently, the African Union has issued a common position on international and cyberspace. Brazil has issued its position as well. So, And there is a lot of appetite for, on the part of these states to develop their positions, but as Kubo rightly mentioned, the capacity is lacking. And when I say capacity, it's not the capacity to actually understand international, it's the knowledge. There's a huge knowledge gap because, you know, these diplomats, legal advisors working in developing countries have to deal with so many topics. So they don't have time to delve into the nitty-gritty of cyber and international law. So it's very hard for them to discuss these issues at the same level. So we have to build their legal capacity to be in a position to develop these positions and to discuss these issues and to find common understanding. Now, what we have noticed in terms of capacity building recently is that, you know, they tend to be Western focused or Western driven. So a lot of NGOs or institutions that are based in the global north, they just tell states in the global south what the law is. I don't think that's the right model. I think you have to go there. You have to go to these different places and engage in a meaningful conversation and exchange of views and, you know, ask them what did they think? What are their concerns? You know, and this is something that we are trying to do here at Chatham House with the Organization of American States and a project, right? We have also collaborated with the African Union on that. So that's, you know, what we call recipient-led capacity building. I think that's what needs to happen. And I think there was a question about allies, countermeasures against our allies. I mean, I guess you have to look at the facts, right, and the conditions. And I think what's important there is that, you know, countermeasures need to be fit for purpose. They have to induce compliance. And so if they're not going to be, if they're not necessary to induce compliance by an allied state, then they're not fit for purpose. They have to be proportionate. So all of these considerations apply, you know, in respect to all unlawful acts in cyberspace and beyond.
Thank you. Shazad?
Yeah, so maybe I'll pick up that question on squeamishness around the term offensive cyber. So I use effects primarily because in GCHQ we've been doing effects and using that word for 20 odd years, and offensive cyber is a term that's only really risen in prominence much more recently. The other reason why I tend to stay away from that term, offensive cyber, is because it suggests that there is a kind of opposition with offensive cyber on the one hand and cybersecurity on the other. In fact, I remember listening to a debate about 3 years ago where you had two speakers arguing for offensive cyber and two speakers, including a good friend of mine, former CEO of the NCSC, Kieran Martin, arguing for defensive cyber, as though it was a binary choice between the two. And as I said at the very start, you know, cybersecurity is the bedrock of responsible cyber, and cyber effects is something that is a tool in the armory, but you can't get away from the fact that cybersecurity is at the heart of all responsible cyber. And so in using offensive cyber, it sometimes creates this idea that you have to choose between the two, and that one is better than the other, and that's why I personally tend to stay away from the term. But of course, when we talk about offensive cyber, we mean effects operations. The two are synonymous.
Thank you. And I think that was Mary's question, so I hope that was useful, Mary. We've only got a couple more minutes, so I'm going to, a last chance for anybody here in the room to raise their hand for a comment or a question, and also then we will pick up one question here online. We'll have the gentleman there, and we'll have a lady on the side as well. Thank you.
Yes, hi, I'm Jerome Peary from Chatham House. So my question is, if you're a big cyber active state looking to support a smaller, less capable state, how do you verify that they have undergone the cyber attack that they say that they have? And also, how do you ensure that they are being responsible in what they target and that they are indeed looking to induce compliance rather than being punitive? Thank you.
Thank you. Please.
I mean, my voice carries, so... All right, yeah, sorry. So for disinformation campaigns, do they fall under the category of malicious cyber activity? And if they do, what kind of countermeasures would be used to deter them in the future? Okay. Especially in reflection of the elections that are coming up. Thank you.
Indeed, thank you. And then just one more from online, which we have from Robert Young. He asks, do you think the interest on countermeasures in cyberspace will help advance and clarify the concept and use of countermeasures in international law more generally, which I think is a really interesting question. Because obviously cyberspace, we're seeing these national positions come out, which is quite unusual in other areas of international law, but it's important to bear in mind that bigger picture. So I think 1 minute each from each of you on anything that you've heard in those last few questions, that is. Talita, would you like to pick up on that? Because this is something that you mentioned in your paper, I think, or you talked about.
On Robert's question.
Yeah,
absolutely. So cyber has become a testing ground for international law because of, all of these debates about very fundamental rules of international law applying in cyberspace. But as we know, as I said before, what happens in cyberspace doesn't stay in cyberspace. It has ripple effects, in other areas of international law, and that applies to countermeasures. So that's why it is very important that when discussing these issues in the cyber context, states base their positions, they ground their positions on existing international law, at least as a starting point. And even if they are considering changing the law, they should consider very carefully what the implications of those proposed changes are on the whole architecture of international law, because they can be quite significant.
Yeah, thank you. And Shazad, I don't know if you want to add anything on that.
Yeah, so just on that same question, I think it's really, we wouldn't be having a conversation about collective countermeasures or countermeasures at all in the way that we're having it in the context of international law generally if it wasn't for cyber. So I think in that sense it's really helpful to think about it in a cyber context, but we do have to voice some caution that the tail is not wagging the dog in a sense, and that what we might think about in a narrow context also applies in that broader international law context, and that we don't have some unintended consequences just because we're talking about cyber. Maybe in 30 seconds, I might just very quickly pick up the point about public-private partnership, and only to say that one of the, well, first of all, when I talked about the principles of responsible cyber, and I talked about inclusion as being one of them, that really went to the heart of this concept of public-private partnership. And that's essentially what we do every day. We wouldn't be able to achieve what we achieve in the cybersecurity space in particular without that partnership with industry. And one of the things that we are in the process of doing, and actually launched in February earlier this year with, amongst others, Microsoft, was the Pall Mall process, which was about how you deal with the proliferation of cyber tools and services into the hands of other states and non-state actors, which is completely transforming the cyber landscape. And we see this as a really difficult and dangerous issue, and one which can only be solved through that partnership. We'll stop there.
Good to hear. And Nino, I don't know if you want to comment on that, or we've, as you've probably heard, had a couple of questions on disinformation and on collaboration and making sure that your partner is doing their due diligence.
Look, really, also in the interest of time, I think I'll focus on the last bit and just go +1 on everything that Shazad has just said. I think he referenced the Pall Mall process and what it's trying to achieve. Overarchingly, I think, and related to this, just combating cyber mercenaries in general has been a big thing for us, and something that we had also recognized as an important topic in this space. So just by and large, and perhaps from our perspective to close us out on this, all of those issues really are so tricky that the only effective way to tackle them sustainably and in an effective way that's going to help you not just today but also tomorrow is by finding these effective, not just public-private partnerships, but really multi-stakeholder pieces that also then bring government, industry, and civil society together. I think those really are, I think that is where our common attention should go, and where I think we should focus when it comes to defeating threats emanating from cyberspace.
Thank you very much, and I'd like to thank all of the panel for a fascinating set of insights. I did want to just sum up very briefly some of the key takeaways that I've heard here, which is really about this sort of theme about the importance of collaboration. There's obviously a massive rise in cyber activity, malicious cyber activity, which is very concerning, especially in a year of elections. But collaboration is one of the keys to tackling that. I suppose Countermeasures are part of the toolbox, but we've I think, emphasised the importance of executing those in accordance with international law, which isn't always straightforward. But with papers like the one today, Miles and Federica's, which I think has been referenced on the chat as well, that helps to sort of see a way forward and try to pull together all the different views that there are on the law, which is clearly in a state of development, particularly when it comes to collective countermeasures. But I think what we have identified is this sort of trend, sort of impetus towards greater support for collective countermeasures, perhaps particularly driven by the Russia-Ukraine situation. And it will be very interesting to see what happens when the G7 ministers meet in June to make their decision about the billions of Russian frozen assets. I think my final point would just be that there's obviously a lot of rules on countermeasures, but there's other rules that are in play as well. Attribution, there's rules on aiding and assisting. There's obviously the primary rules of international law, and they're all part of the mix. And hopefully, I think we have shown that international law can be a real tool to achieving meaningful action. So thank you so much to all of you in the room for your active participation. And to those of you joining online, thank you very much. I'm going to bring it to a close now and say goodbye to those online, including you, Nino. Thank you so much for coming and for your participation. For those of you that are in the room, we're hosting a reception upstairs. We're having drinks, so do come up and join us in the Neil Malcolm room, and hopefully we can continue the conversation then. Please join me in thanking our panel, and thank you.